Good afternoon and welcome to the Hudson Institute. My name is Urška Petrovčič and I'm a senior fellow at the Hudson Institute. I will be your host today during this event on 5G leadership, the IP side of the story. We have all heard a lot about 5G. 5G is set to bring transformational changes to our lives. It will not be merely a marginal improvement over previous generation of cellular standards. It will bring instead what many have defined as the next industrial revolution. Perhaps the easiest thing for us to imagine are self-driving cars that will be made possible by 5G, but we will see similar revolutionary products and services in other industries too, including in healthcare, education, energy, retail, and others. Considering the impact that 5G will have on almost every single aspect of the economy, it should come as no surprise that policymakers are increasingly focused on 5G. They have become concerned about the national security implications of 5G. They have also talked about leadership in 5G. 5G is, of course, a very broad term. It's used to refer to many different things, including infrastructure, hardware. Today, we will focus on the 5G standard that, as some have pointed out, is the foundation or the blueprint of the entire 5G ecosystem. So when talking about leadership in the context of 5G standard, some commentators have relied on a very simple methodology. They have counted the number of patents that each company has, and based on that, they have identified the so-called leaders in the context of the 5G standard. And we have seen that some policymakers have based their decision by looking at those conclusions about leaders in 5G. But is patent counting the right methodology to identify those companies that have made the most valuable contributions to the 5G standard? Is a different, more accurate methodology more desirable from a public policy perspective? Or would that just complicate things too much? We have today with us a distinguished panel of speakers that will address these and other questions. We have with us David Thies. He is a professor in global business and director of the Tasher Initiative for the Management of Intellectual Capital at the University of California, Berkeley. He has authored over 30 books and 200 scholarly papers, and he has been cited almost 170,000 times, according to Google Scholar. Dr. Thies has been ranked as the world's most cited scholar in the combined field of business and management. He is co-editor of the Palgrave Encyclopedia of Strategic Management, and he has received 9 honorary doctorates and has been recognized by royal honors. We have with us Kirti Gupta. She is Vice President for Technology and Economic Strategy at Qualcomm. She is responsible for leading the substantive direction of the global intellectual property and competition policy and advocacy efforts of Qualcomm. She is also responsible for developing economic models for determining Qualcomm's optimal IP strategy and for designing algorithms for IP portfolio evaluation. Prior to her role as an economist, she spent over a decade as a wireless system engineering expert. Dr. Gupta is the co-inventor of 10 granted US patents and several pending patent applications in the field of wireless communications. She holds a master's degree in electrical engineering from Purdue University and a PhD in economics from the University of California, San Diego. Last but not least, we have John Putnam, who founded Competition Dynamics as a platform for economic research and testimony at the intersection of intellectual property, competition, and international trade law. Before founding Competition Dynamics, he held the chair in the Law and Economics of Intellectual Property at the University of Toronto. He also held academic appointments at Boston University, Columbia University, Vassar College, and Yale University. Dr. Putnam holds BA, MA, and PhD degrees in economics from Yale University, where he specialized in international macro and R&D economics. He received fellowship at Yale and Columbia Law School. Dr. Putnam's PhD thesis, The Value of International Patent Rights, was the first to measure the global value of patent rights. Welcome, everyone, and thank you for being here. So let me just start with a very broad question for all of you. Is counting the number of patents a reliable methodology to identify the companies that have made the most valuable contributions to the development of the 5G standard? What does the economic theory teach us about patent counting? John, would you like to go first?
Sure. Well, this topic honestly was what launched me on my graduate career. I started counting patents myself back in 1980, and gradually became, aware of all the deficiencies of doing that, and eventually decided to write a PhD thesis that determined a better way of doing it, and that solved the problems with patent counting. So, insofar as this is an ideological topic, I am firmly in the anti-counting camp, and I think the simple reason is because patent counting is correlated with patent value, but only very poorly. So if you've got a very poor indicator of something, there's enough truth in that indicator to be dangerous, but rarely enough truth to actually guide you to the correct answer. And that's true not only on a national level when you're counting patents as between countries, but especially when you're looking at much smaller portfolios like the portfolio of a company. So if you're trying to compare which company is more innovative, and you are counting the sizes of their patent portfolio, you will rarely make the correct inference. And what we see in 5G as well as in prior disputes between companies is that people assert leadership based on the number of patents that they have. And while there is no information in that total, it rarely allows you to determine who the number one or the leader is. And that's especially true recently where in the FRAND context, firms are able to actively manipulate the total of patents that they have for strategic and public relations reasons. So in addition to it being a poor statistical indicator, you now introduce systematic bias. And so for those two reasons, I would say that this is a very timely question, and it's only sort of the latest iteration of a problem that stretches back a long time, and it's difficult anyway, and is now subject to active abuse for political and commercial interests.
Thank you. David, would you like to comment on this?
Yes, and I'll comment a little bit on what Jonathan said and on your opening. And I agree, of course, 5G is an incredibly important set of technologies, and keeping the 5G ecosystem robust requires getting these issues that we're discussing correct, because it's very important that the enabling technologies, which are in the foundation layer, get appropriately valued and priced, and that the open innovation system that exists for 4G and 5G, and hopefully for 6G that will follow, it's very important that there be incentives to continue to invest in R&D so that the innovation machine keeps going. Yes, the whole question of who are the leaders and what are the appropriate royalty rates, has led to some focus on patent portfolios, appropriate to focus on patent portfolios. But in terms of determining the value, historically, of course, this has been worked out just fine through negotiation in the marketplace. But in recent years, as the ecosystem's gotten larger, and there are a whole bunch of new players that have come in, the traditional markets transaction and voluntary trade environment has gotten upset. And so you've seen injected into the courts when there's patent disputes now around FRAND rates, the effort by some parties to use patent counting as a measure of value. And as Jonathan pointed out, everybody knows that has studied patents that they're at best only weakly, there's W-E-A-K, weakly correlated with the economic value. And of course, it's the economic value that matters. we've known for a very long time that there's tremendous skewness in patents, that most of the value is with a few in a portfolio. And for a long time, economists have known that there's been a lot of noise, but as Jonathan pointed out, it's now beyond noise. There's a lot of bias in patent data because nation states, China being one, but not the only one, have engaged in subsidizing the patenting process so that you have countries and companies that are inventing patents rather than patenting inventions. And this dichotomy needs to be understood, that there is bias now in patent statistics. And so one, they were never particularly good indicators of value in any case. And now the whole process has become politicized and become strategic. So this reminds me actually of two aphorisms that I've found to be kind of useful. One that's attributed to Einstein, where he says that not everything that can be counted counts, and not everything that counts can be counted. And I think this applies to patents. It's very easy and it appears somewhat objective to start counting patents, but as any good economist knows, that's a long way from establishing value. Alan Greenspan, the former head of the US Federal Reserve, once said that it's better to be roughly right than precisely wrong. I think that many of the efforts that I've seen to count patents, and you're aware of the fact that I've been critical of the top-down method. These methods are full of false precision. They look scientific, they look objective, but frequently they're anything but. So the challenge here is to get it roughly right. And of course, the place to go to establish value is not by counting patents, by looking at market transactions. And there are market transactions, there have always been market transactions in the around technology, and the marketplace is the right place to go. So you might ask, why don't people go to the marketplace? Every economist knows that the best measure of value is what something's worth in the market. Well, we did it that way for many years until some theoretical economists said, hey, listen, we have a theoretical problem here called patent holdup, and we have another theoretical problem here called royalty stacking. And these were neat little stories, neat little models that were trotted out and presented as being applicable to the licensing market when they never were. For instance, the whole notion of royalty stacking assumed that every patent has an injunction wound up in it, and it represents monopoly power, which is abject nonsense. So the only reason we're here talking about this is because in the context of complex litigation, some economists started wheeling in patent counting as a way to establish value. No licensing executive would start that way. Historically, no one started in the marketplace asking for the number of patents. They always say, show me the best patents you've got, the so-called proud patent approach. And so anyway, we're having this discussion because what is plainly obvious, namely that the way to value technology is through market transactions, has been challenged theoretically, but not by any credible empirical evidence. Sorry for the speech, but I thought it might be helpful.
Thank you. Kirti, do you have any comments on patent?
Thank you, Urška, for the question and also for the introduction on 5G, because I think we need to answer your question by addressing why you're asking this question in the first place. So, quickly about 5G, it isn't just 4G upgraded, right? 5G will connect every car we drive, every home we live in, every appliance we use, every computer or smartphone we own. Simply put, this technology is designed to connect, all things to each other, not just people to people. So while many of us have heard about 5G, I think it's just important to recognize that It isn't just, your phones or your infrastructure or, Verizon and AT&T deploying networks, or, the MediaTeks and Qualcomm making the chips. But really underneath all of this is this foundational technology, the science behind 5G, what you just referred to as the blueprint, which is where the R&D happens 10, 15 years in advance, which is where the standards are creating, which is where patents come into play. Now, this is, why you're asking this question, because all of a sudden, more than any other generation of wireless, 5G has become important for national security, technology leadership. It isn't just about commercial interest and patent litigation anymore. It's about ensuring, whether nation states are leading in some of the key technology, fundamental technology of future communications. And that's why we suddenly see this emphasis and in these sort of news articles about, who's leading in 5G, and is China leading in 5G, or is US leading in 5G, et cetera. Suddenly, people have started counting patents just to determine technology leadership in this space. Now, back to economics. We are all economists here. We all recognize that there's this vast literature in innovation economics that articulates that distribution of any innovation is enormously skewed. Some inventions are home runs, others aren't that valuable, and that's just the nature of inventions. This is why venture capitalists invest in 10 startups, recognizing that only one will succeed, and patents are unsurprisingly no different. So, John Putnam mentioned this 30 plus years of economic literature in patents has demonstrated this same skewed distribution. And David mentioned this too. I did my work in the industry in this, and I found actually, really little correlation between patent counts and any, indicator of economic value of patents. If anything, more, considered reliable indicators in the academic literature, like citations, also have, quite a limited relevance, if you will, but at least there's some correlation there. But regardless, people have done this work based on many economic, proxies for economic value of patents, like market valuation of firms or renewal rate of patents in patent offices, and have found that patent counts really aren't indicators of value of patents. This is sort of not a, question in the literature anymore. I think it's established in the literature on patents. So to me, therefore, by, counting patents by analogy is like counting the number of coins in one's pocket to determine how much money you have, without paying any attention to the denomination of the coins. So, you may have, a lot of pennies and a dime, and John may have $1, but if we attribute the same weight to all the coins, then you have more money than John, then that, doesn't make any sense. So I hope that, we move away from patent counting. It's recently become particularly fashionable because of the, political and economic importance of 5G, but we need to look beyond.
Thank you. So there seems to be a general agreement among the three of you that it's well established in economics that patent counting is not a reliable methodology to determine the contributions of a company. But as David mentioned, we do see courts relying on patent counting sometimes when determining damages for patent infringement. And that's particularly true in the context of standard essential patents. We have seen the UK court in Unwired Planet v. Huawei relied on patent counting. We have seen a US district court to rely on patent counting in TCL v. Ericsson. Is this problematic?
This is David. Yes, it's very problematic. And to be clear, Justice Perverse in the UK used it only as a cross-check. So he was showing from the beginning great skepticism, and I think that skepticism is well placed. Nobody yet has come up with, and this was the application of the so-called top-down approach, in terms of what the total value is, no one has really come up with a credible way of doing that. So, you know, I would leave in reserve the fact that somebody may at some future time be able to improve that methodology, but I've seen no sign of it so far. And there's so many assumptions that have to be heaped on so many assumptions to do it, that the very best case you can make for it is that it's, you know, one of many, many indicators. It's certainly not a finishing place, but you might be able to get some rough idea that someone is active in patenting, but from patent counts, but not much more beyond that, because it's not in any way as yet a fundamental measure of value. And I know that there was optimism at first that, in fact, that might be the case. You know, my colleague Bronwyn Hall at Berkeley and many others, I think initially, you know, started down this path as Jonathan did, with hope that this, looking at patents and correcting, weighting patents for quality measures, various quality measures, there was hope that it might lead somewhere. But I think we have to say 20 years later, 30 years later, the emperor has no clothes, at least for purposes of determining, you know, coming up with good indicators for purposes of either A, determining value in a court, or as Curtis says, B, for measuring who's ahead and who's not ahead. You know, if you just got a whole bunch of low quality patents, that doesn't establish your leadership in a field at all. It establishes your leadership in patenting, but it doesn't establish your leadership in patent count, excuse me, in patented technology.
I think, Urška, I think I would just add to that. I agree with everything David said. Except I will make one modification. I think there's two things going on that you allude to in by your question. One of them is that in general, patent counting is completely irrelevant to patent damages analysis, because in patent damages analysis, you only care about the value of an individual patent. And there's actually a well-developed set of, you know, law, especially in the US, but elsewhere also, on how to go about establishing the value of a patent, what's acceptable and what's not legally. It's only been recently that people have cared about, not about the damages for an individual patent, but about the value of an entire portfolio, because the question under the international rules is not whether an individual patent has value, but whether a patentee, a patent owner, has made a fair offer to license his entire portfolio. And so courts have had to come to grips with this question, which is not really a damages question. It's, did you offer to license not the individual patent that you may be suing on, but all of your patents on fair, reasonable, and non-discriminatory terms? And that turns out to be a hard question to answer, and it's really not a damages question. So, and there isn't a very well-developed jurisprudence around measuring the value of patent portfolios, and you see courts struggling to come to grips with this problem and failing in part because they've been offered methods that are based on patent counting and are therefore completely inadequate. The other point I think it's worth making is that what you're trying to do, the structural problem that you're facing is you're often trying to determine things, not just damages, but even liability itself, based on whether a portfolio has the value that somebody asserts that it does. So for example, if I sue you on a patent, and then you defend yourself by saying that I didn't make a fair offer to you, and if you're correct that I didn't make a fair offer to you, then I will have breached my commitment to make a fair offer, which means the consequences of which is that my patent is unenforceable. So there's a bright line consequence, which means that my patent may be worthless if you can prove that I didn't make a fair offer. And so in this environment where you've got this huge statistical uncertainty surrounding the value of a patent portfolio, you're making binary choices as to who wins and who loses based on a very fuzzy concept. And that's also a highly problematic situation where lawyers and judges are tasked with making a determination that's inherently statistical in nature but lacking the tools themselves as well as the statistical evidence to make that determination. We say this, for example, in the FTC's case against Qualcomm, or Apple's case against Qualcomm. They allege that Qualcomm, in effect, charged too much for its patent rights. But the question is, how would you know? And what's the error band around that estimate? Nobody knew the answer to that question. And there were tens of billions of dollars at stake in the answer. So it's once courts get involved in this inherently uncertain environment, it's an extremely difficult problem that we face structurally. The one modification I wanted to make to David's statement that there is no way to actually value patent rights in this context is we've actually worked really hard to come up with a value for 5G, for example. And the way that we do that is by looking at the price of handsets and seeing, going back to David's point, which is right, going back to the marketplace and saying, what's the value that people put on 5G as a technology, controlling for all the other features of a handset. And it turns out that with sophisticated statistical techniques, you can actually figure this out. So just to preview, we did this for 4G, for example, and the value is in excess of 20% of the value of a handset. So you can actually put a precise value on that, and you can decide, maybe as a matter of policy, how much that value should be allocated to patent holders or to the people who implement the standard. But there is a way of actually putting a fair market value on the value of standardized technology. And so I don't want to give the impression to the viewer that we are entirely at a loss for how to do that, because I think that's not true.
And Kirti, you're from the industry. So may I ask you, what do firms do in practice for negotiating royalties for standard essential patents? Do they count the number of patents? Do they use a different methodology? Do they look at citations? What is the method typically used?
So, as most serious licensors are licensing a large portfolio of patents, often a global license. So, for example, Qualcomm's portfolio is over 140,000 patents and applications and counting globally. So it's really impractical to count the number of patents, when you're doing licensing negotiations. Broadly, in this industry, like many other R&D intensive industries, what happens is that there are really just a handful of players who are sort of R&D players. Let's say they do long-term R&D because, there's sort of this barrier to entry of high R&D intensity, long-term, enormous high sunk costs. And then, others are leveraging these firms' efforts as sort of an R&D arm to the industry. What I'm trying to say is that there are sort of a few players active in doing this sort of long-term R&D work and are patent owners and are actually monetizing those portfolios, and a long tail of others who are, basically entering the licensing negotiations to utilize those patented technologies. So given this dynamic, there just aren't those many, players that are licensing actively or that have many patent owners. It's easy to recognize the industry dynamic where people generally know who are the leaders in technology, who have the key inventions in different, technology areas, and have a general sense of the, relative value across different companies' value. And we saw this, right? We saw this play out in litigation and discovery where, companies like Apple were recognizing that, we know that this company has a valuable portfolio, but this company doesn't and this company doesn't, or we have a general sense of sort of the relative value. The other thing I think, like David mentioned, is, the use of proud lists and things like that to get, some sense of, value of, patented technology. And finally, I would say, when it comes to standards, remember that there's another important, handy facilitator of information going on. When it comes to standards, most companies who are actually using this technology are coming to the standards for the last 5-10 years and participating together. So they have a general sense of already of the technology, what's in the standard, because they have to implement it, and who are the key players and what the nature of their invention is. So there is actually a far more availability and symmetry information inside than we seem to think exists outside and try to capture the data.
Thanks. I just want to go briefly back to something that we mentioned earlier, and that's the top-down methodology that is used sometimes in patent litigation. David, I know that you have published recently a paper that has criticized the use of that methodology for various things, but including for the reliance on patent counting. And some academics have commented on your article, and they have said that although you may be correct in theory, they have questioned whether there are reliable methodologies for estimating the value of standard essential patents on a more granular level. Do you have any response to those comments?
Well, first of all, I'm delighted that people are saying I'm right in theory. Also think I'm right in practice. And the methodology that is available is to rely on market transactions. Now, market transactions, I think, are made by people, to quote Curti, that are sort of in the know. And the truth of the matter is that people on both sides of a license negotiation, they're in the industry, they're in the marketplace, they know exactly how the technologies read on the applications and the uses. They know, and the job of an outsider is much more difficult. So I'd say, one, the gold standard is always going to be a market transaction. And the only reason why that has been clouded in the past is because of these two specious arguments about patent so-called hold up and about royalty stacking. The literature is now clear, and I think most people, and even the courts, understand that hold out is at least a significant, if not a much more significant problem than hold up. No one's ever been able to prove hold up ever, but there's certainly many cases that are pretty transparently cases of hold out. And I think most people realize as a matter of theory that the royalty stacking story about complements is not applicable in the case of patents, because patents are not the kind of monopoly that is needed to make the royalty stacking story work. Now, Jonathan says that, well, maybe there are some new econometric methods that may help one get at least a better view of the total, the top down, the top part of the top down. And, you know, I suppose we can stay optimistic. There's some possibility of that. But even if you get the top part right, you've then got this apportionment problem. And using patents to apportion, I think is not correct for all the reasons. It's not accurate. It's full of false precision for the reasons that we've indicated. So I can see how, you know, establishing that the total value of the technology is worth, you know, 20% of the retail price would be a good number to have out there as sort of a North Star to give you some sense that there's real value here or not real value, depending on where the number is. But I don't think it resuscitates patent counting as the ultimate test for value. Is the very best a weak indicator.
Thanks. So it seems clear that patent counting is not a good methodology in litigation. It's not good for innovators. It might overcompensate those that have made minor innovative contribution, and it might undercompensate those that have made very important innovative contributions. But is there a broader problem with relying on patent counting? Are we creating wrong incentives for market participants or perhaps for governments?
Yeah, that's, you know, I think I would be very concerned about that, right? And I think you mentioned the Unwired Planet versus Huawei case where, you know, the court did actually rely on the market-driven approach that David mentions, which we call the, you know, comparable licenses approach. They said that let's look at the set of licenses from Unwired Planet and from Ericsson, because, you know, the company had purchased a lot of patents from Ericsson in the past as sort of a universe of relevant, you know, comparables, if you will. And that makes a lot of sense. But, you know, in the same case, the court cautions, they said, you know, negotiating licenses based on counts of patents ignores this idea that, not every patent that you're declaring to the standard as, relevant to the standard is actually ultimately going to be essential. And you're creating this perverse incentive where you're making these companies want to declare a lot of patents to the standards and saying, here's a wholesale list of patents, and we think that they are all going to likely to be relevant. This, quote unquote, over declaration problem. So if we want, already there were commercial interests to do this, and there will be if courts continue to endorse an approach like this based on counts of patents. They're going to incentivize companies to over declare, and that, along with the political considerations of the importance of 5G, just blows this problem out of proportion and actually does what is against the interests of many policymakers today, where in Europe and other places where there are sort of initiatives to enhance the transparency in the system, to make sure that people have actually a better list of what are the actual kind of more relevant list of patents that are related to these standards. So the problem is so big, the standards are so large, and I think this is a point that most people miss, that 5G standard is not just one document. It's a set of 1,500 documents over a number of technology areas, from high level protocols to low level protocols to security to billing, etc. It can fill a room. So nobody can, actually look at patents and say, oh, these are essential, these are not essential, this is how I'm going to make the system be more transparent. It's really possible to do that by incentivizing companies to neither over declare nor under declare, creating the right set of incentives. And what we are doing by counting patents and valuing companies according to that is really creating a disincentive for clearer information.
Thanks. Any other comments?
I would just like to add, returning to the problem that courts face, is that you now have another wrinkle in the system, is that prices are increasingly set not in pairwise negotiations, as David mentioned, but by courts, and they're being set globally. In fact, courts are now competing to set royalty rates. So China will have decided that China is going to decide what a Chinese company should pay a non-Chinese company for a royalty. And in China, you can get an injunction, where the Chinese court purports to tell you that you can't sue the Chinese company in another country. And you must desist. If you want to enforce your patent in China, you must desist from enforcing it in India. And then, of course, the Indian court says, well, we're giving you an injunction against that Chinese order. So now it's gotten to be like kindergarten politics. But it's kindergarten politics with global ramifications, where courts and then administrative agencies are purporting to set prices. And so instead of a situation which could be managed, which is an individual patent owner claiming that its portfolio is valuable because it has lots of patents in it, and then being told that its portfolio is, by the marketplace, its portfolio is not valuable because it's just boasting. That's a situation you can manage, because people actually do the work, as Security said. They do the work, they look at the claim charts, they evaluate the claims, and they say, I don't care how many claims you've got, your patents are not worth anything. That's fine. But when governments and courts in service of governments are in effect conducting worldwide industrial policy by setting prices independently of what private agents think, and they're relying on patent counting methods to do it, then you have a systematic, you have a difficult data problem that becomes a structural weakness that actually does disincentivize the investment in R&D, because you know that you won't be able to charge a market price for your technology. You're at the mercy of rate setters in other countries who are, of course, going to make decisions that not only are not based in economics, but that are based on political benefit to their home firms. And that's an extremely, I would say, dangerous way of divorcing market forces from compensation to inventors, and ultimately disincentivizing discovery.
Thank you. David?
Yeah, let me just build on what Jonathan just said. This really is a serious issue. What you have with the Etsy-based mobile phone ecosystem is actually the world's greatest experiment in collaborative innovation. And it's worked up until quite recently, it's worked quite well. And it's a tribute to a system of decentralized rule of law system with a standard setting body that was not trying to favor any country, not trying to favor innovators over implementers, but trying to create a fair distribution of returns because they were interested in the innovation ecosystem prospering and being innovative. Now, and when there were a relatively small number of players, they sort of kept to those norms. What's happened now with enormous amount of new entry, particularly players from China, the focus, but it's not just players from China, it's also some other large companies that are very short-sighted, don't have a long view, or don't understand what they're mucking around with. What you have is the open global system is being challenged by people just trying to get the best rate, quote, for themselves, rather than thinking about what Etsy was thinking about, which is how do you maintain a global, open, innovative system. And so individual companies pursuing their own legal strategies and engaging in the kind of things that Jonathan was referring to really risk the breakdown of the entire system. What happens in that then? You know, we end up with a number of vertically integrated systems. Maybe we can hold on to interoperability, but the system of sharing technology and technology collaboration and the development of new standards, which has really powered innovation and productivity globally, that's seriously at risk. So, you know, these individual actions by individual companies and individual countries that are not looking at the implications for the global order, or maybe they are and they just want to destroy it, are something we should all be aware of. This has really not struck the consciousness of many people yet, but it's something that's very much in my mind and is in the mind of anybody that's thinking about 6G and 7G that's beyond. Maybe beyond. Maybe if we don't get this right, maybe there won't be a global system of 6G. We'll see.
Yeah, I think that's a very good point. John, I know you're working on a paper titled "The Innovative Output in China." Would you like to share with us more information about what are you finding in your research and how this relates to patent counting?
Sure, yeah, the basic idea, I'll show you a couple graphs in a second. The basic idea is to ask the question, is the number of patents that we observe in China what we would expect given China's innovative inputs? So innovation has the advantage of being a worldwide phenomenon. And so if you invent something, if you get a patent, it's supposed to be new everywhere in the world, not just in your own country. So you have in effect a global production function for innovation to which each country contributes individually. And based on those inputs, you would expect each country to generate a certain fraction of the world's output. So we ask the question, how is China's output different from the rest of the world? And what would you predict China's output to be if it were not intervening in its patent system? So let me just see if I can pull up a couple of graphs right here that illustrate these points. On the screen, you can see the basic phenomenon at work here, which is I've plotted on the screen applications in China between 2000 and 2018. So basically for the last 20 years, 2018 is the most recent year available. I've grouped world patent output into 4 regions: China, the United States, Europe, and everybody else. And you can see, one of these things is not like the others. There's been slow to flat growth in the rest of the world in patenting, some growth in China, some growth in the United States. And then China has taken off from being essentially zero to in 2018, there's about 1,400,000 applications that are filed by Chinese residents in China. The basic reason for this, and this has been investigated in the economic literature, is that China has decided to subsidize patenting. So you get paid if you file a patent application. In certain circumstances, you get paid if you file a patent application abroad. So the question is, how much of this is real? That's really what we're trying to get at. So just to look at real inputs, one of the things that's happened in China is that per capita income is growing. And so again, that's the solid line at the bottom of the screen. And on a proportional basis, per capita income is growing faster in China than elsewhere, but it's still lower than elsewhere. China is still a relatively poor country measured in per capita income. So that can't be the whole story. Similarly, China is investing a larger fraction of its domestic output in R&D, and that fraction is growing more rapidly, and it's now more than doubled over this period. However, the level that it's gotten to is only about the same as the rest of the world and significantly short of a level in the United States. So it can't be the case that China's patent applications are driven by its R&D resources. Conversely, one thing we see is that those R&D resources are not buying as many researchers as you would expect. So the researchers per dollar of R&D has been plummeting. The number of researchers is increasing, but not nearly as rapidly as the rate of R&D expenditures. So it's spending more and more per researcher, and that's because in 2000, the wages paid to researchers were very, very low, and China's attempting to enter the global technical labor market, but that means you've got to raise wages. You don't get more people, you just pay the ones you have more. And so here's really the phenomenon that is at work here, is that the explanation for the increase in applications is really driven by the number of applications filed by each researcher, which again in 2000 was far below the rest of the world at about 5 applications per 100 researchers. And now we have it basically going up by a factor of 15 or so over this 20-year period, to where the number of applications filed by Chinese researchers far exceeds the, on a per person basis, the rest of the world. So if you were to break this down and say, what explains the growth in patent applications, resident patent applications, which is in columns 6, that's the big tall black bar, what accounts for that? And when we look at this, we see that by far the most important explanation is not the other explanations, which are found in the center of the graph, but the one immediately to the left, which is applications per researcher. That accounts for about 80% of the growth in total applications. It's just that the individuals involved are filing many more applications than is happening in the rest of the world. So we can investigate this more formally with an econometric model and divide the production of applications, which is the left-hand side variable here, into 2 components. One is the global production function, which consists of population, per capita income, the share of income devoted to R&D, and the number of researchers per dollar of R&D, times the applications per researcher, which has been what's being subsidized in China. And that explains the total number of applications we observe, not just in China, but everywhere else. So if you take out the China subsidy portion and use instruments for that, you can predict the number of applications that you would observe in China based on its real inputs. And that's what we do. So we also use, we ask the question, for example, is this increase in domestic applications mirrored in China's exports? And again, the answer is no. You see China's patent exports to other countries being markedly below those of the rest of the world. So when all is said and done, the model actually predicts Chinese patent applications very accurately, but that takes into account the subsidy. If you remove the effects of the subsidy and say, how many patent applications would you expect without a subsidy? That number is approximately 200,000 a year, not 1.4 million a year by 2018. So in other words, there's an overstatement of applications in China by something like a factor of 5 to 7, depending on the specification that you are engaged in. And so then the last thing that we do, and I won't go into this too much because it's a little bit complicated, is to say, well, what does this imply about the quality of the patents in China? And it depends on assumptions that you make about whether the applications are actually worth zero or whether they're simply very low in value. And China is actually, patenting applications that wouldn't have been patented, or filing applications that wouldn't have been filed without the subsidy, but are being filed now. In any event, if you look at the sort of the middle set of graphs where it says sigma equals 1.7, the basic point is that the maximum quality of Chinese patents with the subsidy is about 6% of the quality that you would expect without the subsidy. In other words, you're flooding the system with an enormous number of low value or zero value patent applications. And with the result that the average quality of the applications is 6% or less of what you would expect, for example, in the rest of the world. In other words, it's basically junk. Something I'm not going to show you, but I'm going to discuss is we've since then investigated patenting in the telecom sector, which seems to parallel the patenting in the rest of China. Although the inflation doesn't seem to be as dramatic, there's no indication that the quality of Chinese telecommunications patents has increased or may have fallen slightly over time. So getting back to our topic today, what's happening in 5G, the evidence is not consistent with the hypothesis that China is taking over the world's innovation systems. And in fact, what you're getting is more patenting because China is paying its inventors to patent more, not to invent more.
Thank you. This is fascinating. It certainly confirms that giving too much weight to the number of patents might create the wrong incentives. David and Kirti, do you have any comments?
Yes, I think it's a very important and illuminating piece of research. I think most people in the know recognize that the Chinese numbers are inflated, but to show by how much is very important. The 5 to 7x multiplier is a salutary number. But at the same time, we have to recognize that Chinese innovation has dramatically improved. It's just not improved anywhere near what looking at patent statistics would suggest. So I don't want people to think that there's nothing coming out of China. It's just nowhere near what's those that look at patent statistics and patent statistics only might assume. And Jonathan has a very, I think, defensible methodology for making an adjustment. So, I think you're doing a service to everybody through that.
Yeah, agreed. I mean, it seems like, we just talked about perverse incentives and we recognize those are created and we can observe certain aspects of that, let's say in the data for standards, declared standards, essential patents for 5G, et cetera, because we can open, who has declared patents and by how much are those, declarations inflating over the last few years compared to 3G and 4G. And you see like an enormous amount of inflation, compared to before. But seeing it in this way is very interesting. It's a measurable, inflation across the board, right? Like in a macro sense. And I wonder, Jonathan, if, what would the World IP Office say about this? Because, they consistently release reports about the, who's innovating based on who's patenting and the ranking of countries based on patent filings. And we really ought to, work as a community to create indicators that are more reliable than simple patent counts, because clearly that's, was never working and it's, more noisy today than ever before.
Yeah, let me just build on that a little bit. It's actually gone beyond noise. I distinguish between noise and bias. And it's not to say that there hasn't been the strategic manipulation of patents before. I mean, Keith Pavitt at the University of Sussex, writing in the 80s, saying, when he looks at patent statistics, it's how much money they're spending on patenting that is a significant factor. And this was in the UK. You know, my colleague Bronwyn Hall and one of our Haas students at Berkeley, Zidonis, established that in the semiconductor industry in various time periods, that there were, you know, strategic patenting took place. But what Jonathan is showing is something that is, you know, orders of magnitude bigger and greater. So it's not like this is the first time we've seen strategic manipulation of patent statistics. There's always been an element of it, but this is something that is so massive in scale that it really, I think, requires everyone to understand that the fundamental structure of global patenting data is now different and biased.
Thanks. Any final comments?
Well,
No?
I think,
Yeah, please go ahead.
The only thing I'd say, Urška, is that one of the things that concerns me as an economist is the way that misinformation translates into political force. So it's one thing to argue about what's the true number of, you know, patents in China, and this is, you know, in the grand scheme of things, is kind of a geeky, you know, debate. But there is a sense, I think, that people smarter and better informed about current politics than I can articulate more precisely, but there's a sense in which China's actions can be interpreted as trying to obtain by right something that in fact does not belong to China. And that is to dominate, in other words, to make the argument that, because China is dominating 5G and innovative output more generally, then China should have an outsized role in the compensation mechanism by which it's determined which inventors receive how much for conducting what activity. And for people who don't know the underlying economics and who aren't sort of invested in the geeky aspects of this, it can become almost a self-fulfilling prophecy that if China is dominant, then we must listen to what China determines to be the right thing. And I think that should be resisted, not simply on statistical grounds, but on more fundamental principles of justice and equity. But it's not simple to engage in that kind of resistance unless you understand the underlying kind of arcana of how to measure innovative output. So I find the interaction between international trade law and international economics to be quite interesting, but the gap in the understanding between international economics and international law is such that the law can be distorted by the underlying economic distortions. And that's, I think, we would allow that to happen at our peril.
Thanks. Well, with that, we have come to the end of our event. I would like to thank our panelists for this very interesting discussion. I've really enjoyed it, and I'm sure our viewers did too. I hope I will have the opportunity to host you again soon. And thank you all for joining us.
Thank you, Urška.
Thank you.